Can I just follow up on that? That's exactly what I wanted to ask, Mr. Minister. Advocate, good afternoon.
Good afternoon.
My view is that, is this a normal practice? Was the once off? And did it happen again? Or was just because of Advocate Pisos that you've done that? Or is this normal practice and has it done before? And did that practice continue doing that? And isn't that a prejudice? And isn't that a bias? Isn't that creating an opportunity for somebody to come and kind of use it as a bargaining or something like that? But is it a once-off or is it, and was it normal practice? Thank you, Minister.
This one happened, it was a once-off, but about this case, it wasn't the only one. Because after Advocate Pisos left, he never came back. He never came back at all.
I'm just trying to think if we're not getting into a slippery slope where formal and informal seem to overlap. What if those reporting to you had started this practice of allowing for expression of view as a precursor, and those below them, and this became prevalent because the rules, the lines are beginning to be blurred? Wouldn't you worry if that was happening, that now you do have this expression of view prior to? Or would you just trust that you are the only one doing that if this became widespread?
So if I get it correctly, Prof, you are saying if those reporting to me, which is the DPPs?
Yes, and even prosecutors below, they start saying, no, nothing yet formalized, let's meet.
My understanding and my observation is that people do meet and exchange views and engage about the approach to the case, about what they would want to see the prosecutor do. There are informal discussions, even in the lower court. But if it is about trying to get the institution to take a final decision on a point, then that must be formalized, because there must then be consultations. So the generalized back and forth discussions, as far as I understood at least and I observed, do take place in the lower court. It's not an issue. But if somebody now wants a decision to say, this is our view, normally prosecutors would say, please put it in writing and send it so that, and you motivate it so that we see why, and it follows the chain. Because by the time it gets to the NDPP, for example, you have a trail from where it started, how it was responded to by the people at a local level. It goes to the higher up to the DPP, who comments and also puts in writing. So by the time you sit as an NDPP, you have 2-3 stacks of interveners' opinions on the matter, and then you deal with it on that particular basis, because you are reviewing a decision that's already been taken by others. That's how it works.
Thank you, Advocate Similane. I think you are right. By the time it gets to you, it would have been a decision that is taken by others. But what protections would you give to the system that the person, when they go back to come up with the value chain, are not actually saying the NDPP has seen this, or I've expressed my opinion to the NDPP, in that way, bearing weight on them to look at it in a particular way, almost like you do not have a choice because this matter is being handled by the, or even outright, I've spoken to him on such and such a day, you know, that kind of thing. But I just want to refer us to the Code of Conduct of the NPA under professional conduct, which says prosecutors must strive to be and to be seen to be consistent, independent, and impartial. So there's the issue of perception there. And it worries because once you call somebody in your office, when there is somebody defending another person who's accused, it gives a perception. And then it will come back, like you say, now formalized. And it comes back to you as the final arbiter or somebody who is supervising a final arbiter.
Right. The good thing is that it would never ever happen that way. I can assure you that in the NPA, whatever you may have heard, prosecutors follow strictly the channels. It's SPPs, it's control prosecutors, it's the deputies, it's the DPPs, it's the head office, when formal decisions are being taken. But when there's back and forth engagement in a court, they have those engagements as often as they need to have them. But when it's time to make a decision, you put it down in writing so that you understand it, and also so that you consult about what the attitude is, up to until the absolute level. So the concerns you have can never ever arise in the normal course of operation of the NPA. It doesn't work that way at all.
Okay. I want us to move on to the next segment, Advocate Similane, into the legal background. You indicate in terms of
Into the legal?
Pardon?
I beg your pardon.
Yeah, section 2 of the form. Around, maybe check us through your exposure in terms of legal work. I see you've got criminal law,
section 2, yeah.
and we're saying not a lot. Administrative law, constitutional law, labor law. Maybe just take us through that exposure.
The section 2 paragraph.
It's on paragraph 2.2.
Oh, 2.2. Oh, no, these are the areas of law
Yes.
I practice in. I do varying amounts of work. Mostly it's admin law and constitutional law. Done a little bit of labor law. It's not a big area of work. Criminal law is not incidental enough. Compared to what one would expect, I haven't done a lot of those types of matters. I've done a few of those matters. I've done a few family matters, family law matters and Hague matters, but it's mostly admin law and constitutional law.
Then we move to section 4, managerial experience, having led LPA.
Can I ask one question?
Okay, you want to ask on that section of legal?
Yes.
Okay.
Thanks. Advocate Similane, just so that I don't miss this part that you just said. You said criminal law matters, you have not done so many.
Yes.
Does this answer include the period prior your appointment then, moving into the period now? And I understand that as counsel grows in practice, people don't go to do bail for every matter everywhere. But does this also encompass the part, perhaps, of prior your first appointment?
Prior at the NPA?
Yes.
No, I did quite a bit before.
You did
Yeah, I
quite
did
a
quite
bit before.
quite a lot of matters before. Yeah, I did quite a lot of protests.
So you can easily answer to the question, you had adequate experience in the criminal court.
Oh no, before I went
space.
into government, yes.
Yes.
Before I went into government, yes.
Okay.
Yes.
No, that's
Okay. No, thanks. Moving into the managerial, I'm not worried about how many staff you've overseen,
Yes.
having been the head of NPA, but I'm interested in your management style and your leadership style. I see here you wrote in terms of leadership, you advocate and practice the African-Asian approach, which fosters community and village. As a person, I think I'm reading it correct, it's part of a whole. Maybe explain that and also what you see as your management style.
Yeah, it's collective engagement. I don't do top-down. I don't manage people top-down. I believe in communal kind of engagement where you meet the people with whom you work, even if you are superior to them, and you share ideas. That's how I've been managed. It's the only style of management I know. I've always been, from the first time I worked formally at the Competition Commission, it was always group thoughts. We meet as a group, we meet as a collective, we set the plans, the strategies together. Naturally, the leader will help identify the priorities, but we sit together, we agree, we are assigned a role, you come back, you share that role, and you report to the team on a regular basis on your work. Decisions get taken collectively. You decide on what others do, others decide on what you do. So that communal approach, I found that for me, it quickest enables buy-in. You don't have somebody feeling left out because they're just getting informed after the fact that something was done. So when you're together like that, then that's how it works. So the EXCO style is that. What I do when I say I don't manage people, I manage process instead. I set timeframes and dates. So for example, in the Department of Justice, I would say to the DDGs, we're only going to have 12 meetings a year. One meeting a month, which takes place in the first week of the next month, so that to discuss the month prior, so that we collect all the stats for that month and then discuss them the following month. In between, I don't need to see you because we've already agreed on the strategy, the objectives, the plans. Just go and execute and just give reports. So I hold people to account on the timeframes set, the targets set, and then off we go and make decisions that way.
I want to come to in that leadership style. One of the candidates in the my apologies. I think it's a long day. I want to come to the leadership style and acknowledge what you are raising about inclusion, participatory of staff. But one of the candidates earlier on spoke about you being able to undermine those that you lead with, as far as sitting even in panels of junior officials in the appointment process.
Oh, Hermione? Ah, okay. No. No. She's correct about that. That I did do. The context was this. I raised an issue in the organization. I said, you know, guys, or incidentally, we know each other very well with Hermione. After the meeting, we're busy chatting there. I was telling her, how dare you say this about me? She says, well, you know who I am. I said what I had to say. So I told her to say there's no, I absolutely accept what she said, and it's correct. I did do that. Again, you know, you arrive in an institution and you get on with work. As we know, for many of those that work in institutions, officials then come and give reports to the new people to say, look, there's a problem. It's of this nature. Dissatisfied with their work environment. And this was a few. Some people in head office complain about it. Just basic petty stuff. So I was like, nah, I'll talk to you. So I tipped Vili. I said, hey, you know, there's grumblings I hear about in your area. Just keep a close eye on it. Then a while later, I went to address the team just to meet them and see them. And we discussed work in the normal course. Again, nothing hectic, nothing unusual, because I was just loitering to see if I can pick up some stuff on a consistent basis that I could raise formally now with Vili, because he was a good colleague and a comrade. I just thought he needed to be aware ahead of time that there was something coming up. Then when I looked at the work of the unit, I asked just informally, why are there no black people in the AFU? You know, why is the representativity or representation so poor, comparatively speaking? The initial discussion, we're sitting like this in a room. The initial discussion was, yeah, we're looking, you know, we're advertising, we're recruiting. You know, so I said, okay, no, that's fine. The meeting ended, normal course, no biggie. Then we had another engagement with the units, and I raised the question again. I said, no, but why is this issue coming up? And this time I started raising it formally, that I'm getting negative vibes about the place, that this is a preserve. There's no inclusion in this particular unit. And the formal answer that I then got was, we can't find good black candidates to join the AFU. So I said, no, I don't understand how that could be. What do you mean? He says, no, we get CVs, we interview, we don't find appointable people. It got on for a while, then I involved another official, Advocate Chiba, senior official. I said, this.
Oh, they're asking that you bring closer your mic.
I asked Advocate Chiba to join me in some of the meetings. I can't remember what she was responsible for at the time, but I asked her to join and said, no, I hear this thing, what is going on? Then I received a formal complaint from an AFU official to say Vili of Mayor is racist. So I dismissed it. I said, no, you're joking. No, not Vili. You know, it can never be, I know. I said, no, he's racist because we are being made as blacks. There had been then some recruitment of blacks. We are being made to write an English test. So I said, what are you talking about? You're being made to write an English test. I said, no, I'm being made to write an English test. So I didn't believe it. I said, it's not true. Let me see it. So a small sheet was brought to me, and I spoke to Vili about it. I said, Vili, what's going on here? This is what I'm getting. You know, at University of Natal, where I went, it had a program of assisting students for whom English was not first language. And as part, it was a bridging program. It was called English Language Studies, to help them bridge before you do English 1, 2, or 3, if you wanted to do that as a major. This was worse than that. I called Will, I said, Vili, this can never happen. I can't get this from you. It can never, ever, ever happen. He said, no, we're just trying to do basic tests. I said, it can never happen, because it creates the perception that I've had. I know it's not true what they're saying, but that's how they feel, because they see this kind of treatment. He says, okay, no, then I'll stop it. I said, no, don't worry about it. Let's not go ahead with it. I'll go and engage with the officials. So I went and engaged with the officials, and I basically indicated to them that whatever their perceptions were of him, it really, I understand why they would feel that way, but it definitely was not what they were describing. He's absolutely not like that at all. They understood, they said, we understand, but we didn't appreciate the manner in which we're being approached, because there's this general problem in the AFU. So what I then said was, well, you know, and I spoke to him, I said, well, in the next set of interviews, I'll come and make sure that we're able to see if we can find candidates that can fit the bill. So I spoke to Vili. There were appointments being made in the Western Cape, and I said, I'm going to be in the Western Cape for something, so we're going to be participating in this. He didn't have a problem, right? But then I asked him that, well, if you can speak to your officials about it, so that they're not surprised when they're there. So we arranged with HR, and we went to the Western Cape, and we handled that. In other words, the process was run, people were interviewed. HR had handled everything already, so we just came, we had a look at the pack, we sat and went through interviews, and candidates were appointed, and my submission that we found the candidates that could do AFU work. My argument earlier with Willie, when he said we can't find people, I said, tell me what's so difficult about AFU work. I just want to understand it. Because by that time, I'd also checked that when it comes to briefings to counsel outside to go to court, a pattern was that we largely briefed almost majority white advocates. I said, this is what I want us to engage with, right?
Maybe
So,
just to ask
yes.
there, why particularly go with Advocate Jiba, who was strategy and operation, and not go with the head of FAU? And I'm going back to the theme, because you introduced the theme of ensuring that your heads have power. Your heads don't feel undermined. Now, if it's the process of rectifying, you're wanting to support Vili in finding, Advocate Hofmeyer, in finding the right candidates and also ensuring transformation. Wouldn't it have been better, or why didn't you go with Advocate Hofmeyer, who was the head of FIU? You went with Advocate Jiba, who was not responsible for that unit.
No, he didn't want to go. He said he didn't have to go. At the time, remember, at the time, he was also running the SIU. So I spoke to him about the positions they were filling. And we actually discussed them, that, okay, I'll be going to the Western Cape to go and participate. He said, no, it's fine, you can go. I'll speak to Hermione about it, and you guys can attend to it. It's not a problem. So we had discussed it.
Advocate Cronje was responsible at the provincial level because our understanding, she says that there were 2 people that she reported to, which you jumped from your level to come to her.
No, I don't know those 2 people. It could be true, I don't know. But the arrangement for those interviews was arranged with the head of the AFU, sorry, it's Asset Forfeiture Unit. And I went there on that basis to join those that were there. I don't know who else would have needed to be there, how they had set up the process. All that they just needed to know is that the NDPP would be participating, acting NDPP, I think at the time, would be participating in these particular proceedings with HQ.
And when she wrote a complaint?
I've never seen it. I've never seen it.
The report that she wrote to raise her dissatisfaction.
Never brought with me.
You never knew about her not happiness?
First time I hear about it today.
It's your first time today?
First time I hear about it today. What would have happened in an event, Minister, HR was there, ran the process. HR ran the process together with some of the admin people who were based in the Western Cape office. And what would have happened in normal course is that if anybody would have raised a problem with the process, it would have gone to HR, maybe not there. Let's say, I don't know, I'm trying to imagine that she probably, let's say she thought, let me do it when the acting NDP has returned to Pretoria. That would have gone somewhere. To HR, it gets to HR in HQ, and it gets looked at. And if, for example, somebody is complaining about the NDPP, acting NDP at that stage, I'm imagining that they then would have found a way to take it to an appropriate environment for it to be addressed.
Yeah.
So what would have happened is that it would have come, they would have looked at it without my knowledge, for argument's sake, and they'd have taken it to the department in HQ, where HR reports anyway, and it would have been submitted there. And I'm imagining that should have been asked, is it a formal grievance, for example, or is it just an information issue? Let's assume, worst case scenario, it's a grievance. It would have been a grievance that would have really raised the, let's say, the DG's attention, the DDG, they would have taken to the DG to say, DG, you know, this is what is happening, can this be followed up and taken up? So I'm imagining if there's a complaint of that nature, that's exactly how it would have worked. And if it was not satisfactorily done, I'm imagining that whoever feels strongly about it would have escalated it to the executive authority, because that's a grievance framework in terms of the public service, and it would have ended up in the Public Service Commission to the extent that somebody would have felt aggrieved. But Mr. Hoffman never raised it with me at all, at any point in time.
So you said in the interviews, were you part of the shortlisting process?
I don't recall if I was part of it.
So you
No,
only said
we
in
got,
the
I
interviews.
think when I got the pack was already prepared there.
Who shortlisted, in your knowledge?
Oh, I don't remember who they've shortlisted.
The reason I'm asking it because it makes that process irregular if you didn't shortlist.
I just don't
The
remember.
requirement of a recruitment process is that you would advertise, a panel will be appointed, that panel must shortlist, and the same panel that have shortlisted must be the one that interviews.
Yeah, I don't remember how it exactly worked. I may have been part of actually the shortlist because it was an intervention specifically that I was making, but I just don't remember the details. I don't want to commit, but it's verifiable.
Advocate Similane, I have a difficulty with that. You are a former accounting officer who have run the Department of Justice and Constitutional Development as an accounting officer, who would be familiar with HR processes, because as a Director General, you'll sit in interview processes. You'd oversee the process of recruitment in terms of public service and administration. You'd understand the law and the regulations that requires. I find it difficult that at this point, you would not know that I can sit in an interview if I've not shortlisted, or you do not remember whether you shortlisted. I've been a minister since 2017. I've been a public servant. I can tell you where I've sat in an interview.
Mister, I've sat in many interviews.
I've sat in many.
No, I understand. And that process you're describing is exactly the process. I just don't want to, I'd appreciate if you verify it. I just want to, I just don't remember.
Let's take a step back and park that one.
Yeah, okay.
in terms of public service and administration, as a former accounting officer, you would know the levels of delegations. That at this level, as an accounting officer at a department, you'd have been given, okay, at this level, administrator to this level, non-SMS. These are the delegation that would operate the appointing and all that process. SMS, this is where the delegations and all that. For example, DG, DDG, we go through cabinet, it's delegated powers by cabinet to ministers, and therefore the panel will be ministers. Non-SMS based on public service administration and delegation by the executive authority, which again, in the NPA, the delegation as well are linked to the minister. Now, at the time you sit with this, did you verify the delegation authorities that you could sit in that, or you are violating those delegation of authority?
That I could sit as NDPP?
Yes.
No, I didn't get that far. No, I don't. No, definitely. No, definitely, because the NDPP would not have the delegations for HR.
Exactly.
Yeah, no.
So you shouldn't have said in the interviews, because there is nothing that gives you that authority to sit in terms of the delegation and functioning, how NPA functions and the department, especially on human resource processes.
Yeah, no, I take that point, yes.
Thank you. Okay, let's move to the next one. In terms of the questionnaire, we move to, you've dealt significantly in terms of your significant contribution, where you've gone into detail in how you have explained your role in establishing the Competition Commission, the tribunal, the work in conceptualizing the DPCI. Anything else you'd want to say in that regard? This is section, I must go in paragraph 3, same under section 4. If you've gone extensively, but I don't want to pass in case you've wanted, because you covered it when you started the process. But I don't want to be unfair and jump that part. If not, we can move to the next segment.
Yes, Minister, there's a lot that I've done.
The next section deals with financial and business interest. You indicate that you've got 2 companies. We did receive your letter. Thank you very much. Where you have additional in terms of the company that is also dormant that you'd forgotten to indicate. So that is received. They are currently confirmation that you are currently deregistering them. Thank you. And then we move, okay, the issue of health, no health issues that will impede you from holding the position. And then we go to the issues around, have you ever been convicted? No. But the issue of legal bodies, any complaint, have you ever found guilty of any professional or disgrace conduct and any complaints against you? Do you want to take us through that process, those issues in that segment, where there's complaints, issues that you'd want to bring to the panel and your explanation of them?
Oh yeah, that's the Johannesburg Society of Advocates matter. Yes, I indicated that matter that took place in the process started in 2015, it finished in 2017. That arises out of the Chinwala processes. I don't know if you want me to start there. Do you want me to start there, Minister?
You have an opportunity to explain to the panel.
Right.
And I'm giving you that opportunity.
Right. Okay. Now, this matter followed the Chinwala inquiry, which got completed in 2008. There, it was an inquiry relating to the fitness for the NTPP at the time. As DG of Justice, I then assisted the minister with that process at the time. The way the terms of reference were set and the way government decided it would approach Ginwala was to make a submission. Dr. Ginwala asked those submissions. The reason is because it is initiated by the president at the time. They therefore needed a submission to be made that would be considered. That submission was prepared. It was submitted. In its preparation, because there were no directives as there usually are with the judicial inquiries, this wasn't a judicial inquiry, but there were no directives. There was a due date for government to file a submission. So all information had to be put together. The department was instructed to find legal representatives for the minister and the president. So in the normal course, I facilitated that through the state attorney. The minister, the state attorney made available state attorney to represent them, and through the state attorney, counsel was found for the minister and for the president. And they engaged and took instructions accordingly. They met often. In some meetings I was invited, in some meetings I was not. But the long and short of it is that government therefore needed to put together a submission. So the nature of the issues is that the president would make the inputs in relation to his views to the issues, and the minister would provide inputs in relation to her experience with the NDPP. And this was on the basis that the minister had advised the president that her relationship with the NDPP had broken down. So she needed therefore to have collated and put together all the information that she was going to rely on to demonstrate that. So the department was asked to put together information. We did that. The other departments that were involved were asked to do the same thing. NIA was asked to do the same thing. Crime intelligence was asked to do the same thing at SAPS. So there was a collation. So what I was responsible for as the DG in the department was to coordinate the meetings of all the departments that were involved in that submission. So I arranged meetings with SAPS to tell them when the meetings were taking place, what was required of them, so they would come. Inside the department, those officials who had dealt with the NPA and the DSO, amongst other things, I'd asked them to bring that information. So they all came and would meet and then would brief the lawyers and show them what information we have. And the drafting of the submission, therefore, was done by them and would make inputs periodically. And we discussed it, and up to the point where they then needed to go back to clients, discuss it further, and finalize it because the submission date was imminent. So that got done. So that was the end of my contribution to that process. And the next time the information came back was that the executive authority and the president had finalized the submission. It was now going to be filed. And the legal representatives were responsible for that, then did file the submission with Ginwala. It wasn't the department's responsibility. So it was submitted just as a submission. And then when it was received by Ginwala, naturally it was considered. We then got information back that, or before it was submitted, there was then a letter from the attorneys of the NDPP asking for information. They asked specifically for a letter. Well, they didn't specifically ask for a letter, but they asked for all information, if I remember correctly, I'll paraphrase, that the department had received, the ministry had received, the department had sent, the ministry had sent to the president. So either of you would have sent to the president or whatever, either of you would have received from the president before 15 September, if I remember correctly. So we attended to that. I was instructed to then obviously assist prepare a response to that particular letter. And I did prepare the response to that letter. But at that time, the minister indicated that indeed she has a letter from the president. She had received a letter from the president relating to Pikoli. And she suspected that the president was going to be making a decision soon. She didn't show me the letter. She didn't give it to me, so I didn't know. But the discussion was the reading and the letter from the attorneys is asking for information in relation to the prosecution and arrest of Mr. Selebi. That's how, Mr. Selebi. That's how it was phrased, if I remember the wording correctly. So the point made was that we know nothing about, well, I hadn't received anything as a department. In other words, the department hadn't received anything from the president and hadn't sent anything from the president. So this didn't naturally concern the department. It clearly concerned the ministry. And the minister's view was that I don't have a letter that talks to the arrest of anybody, let alone Mr. Selebi. So that's the response that needs to be sent to these parties to indicate that there is no such. But what was there were all the other reports that had been submitted by the NDPP. So I drafted the letter along those lines, and it was sent. The submission then got submitted to Chinwala, and I was informed that the legal representatives, when they got there were engagements with the legal representatives of the NDPP, and it was in relation to what they still needed from the department and the ministry, respectively. In fact, they'd also asked, I can't remember when, but at a different time, not in the same letter, they'd asked for opinions that the department had obtained. And the department claimed privilege over them and said, no, we're not going to make them available because they're privileged. So in the meeting with Dr. Chinwala and Secretariat, there was then a discussion about what the other side needs to start. I wasn't there, so I don't know what happened, but this is the feedback we received. When it came back, the feedback was that, well, between the parties, because the process would need to start soon, some direction was given by Dr. Chinwala, and it is that, and it was agreed by all the parties that they would exchange what they need from each other. So let there be a discovery process, in terms of which what the other side needs, the department and the ministry must make available, and the other departments as well. They must make available, and if anything is needed from the other side, the same must be done. So with the officials, we put together the information, specifically the two opinions that we had claimed privilege over, and we waived the privilege, and we gave them to the state attorney. The other departments did the same, as far as I recall. And then those were given to the legal representatives, and they attended to their filing with Chinwala. A couple of days or a week or two later, then the process started. So that's how it started. Or in fact, before it even started, part of the feedback was that the legal representatives of the NDPP said the government submission covers too many things in one. And because there's too many things in one, can there be a breakdown of which department is raising what issue and which person in that department is raising what issue? So it was segmented, and myself as head of department, I was then, and that parties must then also put affidavits. That must be done in affidavit form. So I then did an affidavit to cover the areas that related to myself as head of department and accounting officer. I explained the issues that I'd reported to the minister about in relation to the NPA, that I was having difficulty about with the NPA. Basically finance reporting issues as accounting officer. And as in terms of Public Service Act, it was in relation to one or two disciplinary matters, and the building inner chambers that had been acquired by the NPA for which they needed money to refurbish. I put those things and the general issues between NPA administration and departmental administration, where staff were heckling each other back and forth about reports needed to be submitted that were not submitted. So my affidavit was basically circumscribed to those issues. And it was filed. I think the minister, if I recall, did her affidavits, and the other officials from the other departments did theirs. So those were filed, basically discovery. So discovery was done, and the documents went through, and then the process started. Then we went through it. I was cross-examined on my affidavit, at the end of which, naturally, I was excused and I left, and those were remaining proceeded with the process. The next thing I see this, I hear that the general report is ready to be released. We all waited for it naturally, and it was eventually released and it was attended to. So when I got a copy, I then saw these comments that were made by Dr. Chinola in relation to myself. I was obviously shocked by them. I was like, wow, why would these comments be made? Because not only do I not agree with them, but I didn't get an opportunity to be tested on them or comment on them. So how can this be? Processes just ran forward with the removal of the NDPP in Parliament, and this issue got left unattended. And things basically continued in the normal course. Then I got alerted that somewhere in 2009, I heard that somebody had filed a complaint, but initially I didn't get that information, and it sort of died out. But in about 2011, 2012, somewhere around there, then I got information that, no, indeed, you were right, there was a complaint that was filed by an advocate, Ellis, who had filed a complaint with the Pretoria advocates saying that the comments made by Ginola needed to be investigated. And that matter was then referred to the Johannesburg Society of Advocates around that time. At that time, the judgment had come out and I was at home for a while. Then around 2013, I then went to join the Public Service and Administration. And that's when the Johannesburg Society of Advocates then contacted me and alerted me that, look, we've got this complaint about you, can you just comment? So I commented and explained myself. Then they said, no, we believe that we should take this matter forward and there'll be a disciplinary process. I said, no, that's fine, I'll come and explain. It started in 2015. We had exchanged representations which they're not satisfied with. Then in 2015 it started, and we completed it in 2017. You know, found guilty on the way the charges were framed. They were in line with the comments made by Ginola, that you didn't disclose to Ginola the letter of the president. You didn't follow the advice of the opinions. You got yourself involved in the NPA and therefore exceeded the role of the Director General in respect of responsibilities, of his responsibilities for the NPA. You were condescending and arrogant to the NDPP. You accused the NDPP of dishonesty, and then you conceded.
Away from the mic now.
Then you conceded on an accusation you made, and I find that it was without merit. So those comments were mirrored in the charges, and they found me guilty of that. And they recommended that a strike-off application be brought. That was in 2017. Then within the 14-day time frame set, we filed an appeal to say, no, we're filing an appeal with the GCP in terms of the Constitution, and let's attend to this. Never heard from them ever since. Never heard from the JSA ever since. So 2018, 2019, my attorneys engaged them to say, look, we need to have this appeal set up. We filed and everything is ready. When it's going to happen? No acknowledgement of receipt, nothing. They do absolutely nothing. So my attorneys say, no, let's wait. Maybe they will come back. So we wait. I continue with my work. Then reach a point at work in 2022 where I thought, oh, well, I think it's time for me to return to practice. So naturally, I went back. I applied for membership to a group. I got it. And then I went to take up chambers, around about March 2023, and I started phasing out my special advisor role. But my chambers were set. Then, around March 2023, I saw, in a totally different function, the chairperson of the GCP at the time, and I just reminded him, I said, you know, there's this thing outstanding. Since we filed that time, we've never heard from you people. He said, oh, you know what, I remember the thing. You know what, we'll respond to you. A few weeks later, we got a response that GCP doesn't have jurisdiction on the matter. They're like, oh, okay, they don't have jurisdiction. Okay, that's interesting. That was about March 2023, April 2023. Then around June, July 2023, I'm not so sure. The JSA then sent me a letter to say that, look, remember this matter? I said, yes. Said, want to have a look at it. Can you give us representations on new issues that you would want us to consider as we consider that matter? So that looked strange to me. I was like, okay, I'm not sure what procedure this is, but okay, let me do so. So I got my counsel and my attorneys to put submission. We put a 40-page submission, practically expressing concerns that, look, here's correspondence, we've been engaging with you guys from day one, you've not been responding, you've not been acknowledging, you know, these are the views we have. Put a full submission about, you know, the prejudice that's there, why is this thing taking so long, why didn't you move on it? Then, after submitting them, I was then informed that the Bar Council would be meeting around October 2023, and that I was invited, if I was interested, to come and meet the Bar Council and come and make my presentation there based on what I'd written. Naturally, I took it up. I said, oh, of course, no problem. I need to come through. So I went. So went with my legal team. We sat there. Everybody was there in the Bar Council at the time. And then they said, well, we're here, and this is the only agenda. We'll receive your submission. We just want to find out if you have anything else to say. So our approach was simple to say, first of all, tell us what process is this in terms of the constitution of the society, because we've looked at it. There's no provision for this procedure. So what procedure is it? I need to understand what is the purpose of this discussion, because all the decisions have already been taken. The only thing left is for the appeal to be set and be heard. So what is this meeting? And they all looked at each other and said, oh, we're just trying to find a way in which this can be amicably resolved. Words to that effect. So on our side, we said, no, but what procedure? You know, we can engage in a discussion if it's in terms of X procedure, but what procedure is this? Because we're not aware of it. And what amicable resolution can there be in a matter like this? Because an appeal has been filed and it is there. It just needs to be processed in accordance with the relevant clauses of the Constitution. So I went on as well and told them what the prejudice is. And I specifically told them, I said, you know, the problem with this type of thing is that this thing is hanging. And if I need to go and do something, this thing will always need to be explained. You know, I gave them examples in the public service of positions where fit and proper is a requirement. I said, for as long as these things are there, this thing will always be hanging. So you need to finish this. And you've been prejudicing me for the past 8 years, as the case may be, by not attending to this. I said, no, we realize that, we will we'll consider this if there's nothing else to say. So there were further arguments. I don't need to repeat them here, but really premised on the fact that that process and that meeting was just a non-meeting in the sense that what did it have powers to do as far as we're concerned? We wanted to understand that. We didn't get an explanation. So I said, we'll come back to you. So we left. Never came back to me. They never said a thing. I said, oh, okay, these guys are quiet. Then, lo and behold, this process starts. The president puts out a panel. It's in the media. And, that advert or that gazette in the paper, if I remember, it was a gazette, but it was basically the panel. It was put in a WhatsApp group I'm in. And somebody in the WhatsApp group, it's a WhatsApp group of many people really from different parts of the country, different political parties. And somebody in that WhatsApp group said, Menzi, I expect to see your name in there. Words to that effect. I think it was on early in the week, Monday or Tuesday, somewhere thereabouts. I don't remember. It's fine. Then same week, I go to Chambers on a Sunday to go pick up a document I needed to read. And I open my chamber, I get in there, there's a huge box. And I thought it was the document I was expecting. So I go and have a look and I open the box. It's the strike-off launch papers. They're on my desk. I'm like, okay, what is this? I look at it and I see it. I'm like, oh, okay, this is what has happened. And then I attended to it. So I was trying to think what was actually going on. Then it dawned on me that, oh, okay, actually, this is, it appears to be a preemptive move on the part of somebody in anticipation of something. And I left, obviously, and engaged my lawyers accordingly to say, can we look at this thing? These guys have, since 2023, October, they've only come back now with this application. So we checked, obviously, when it was stamped and served so that we comply with the time frames, and we attended to responding to it. So I spent some time thinking about, okay, what possibly is happening. But because they'd moved in this way, my thought was, okay, obviously I'll defend it and see them in court. We will proceed. And we prepared the papers, and we filed since accordingly, and they've since responded. And we've put a counter application to have the matter dismissed. And they haven't yet. Time hasn't come to file their answering affidavits because they asked for an indulgence to file in January, which I acceded to. But they haven't filed their reply to my answering affidavits, and they're out of time. So they indicated that they will ask the court for condonation when they file. They were due to file their reply on the 26th of November. So we're waiting. That matter is sub judice for these purposes, Minister. But that's basically what happened in this particular matter. Now the issue is, to get back to Ginola, what actually did Ginola say? And is she actually correct? Because after the reports were released, her report was released, and it went on, the matter went to court, and it was set aside. Based on the judgment, I then engaged government to say, okay, we need to attend to what the judgment says. And the responses I got was that, no, it will be attended to. We'll attend to it. We'll have a look at it. So in the meantime, the first
Court
thing,
set, you mean the Concord setting
Concord.
aside your
The appointment,
appointment,
yes.
not the report?
no, the appointment, the report, I didn't challenge because I had no local standard to challenge it. It was a comment, those were comments made against a witness. So I had no interest in that inquiry. So in law, I wouldn't have local standard to set aside a report. I was in a process I wasn't a party to. So that's what basically...
But the report makes a finding. I find it difficult, Advocate Similane, that you would say you had no local standing. If a commission finds something against you, I find it difficult to say you couldn't challenge it. You could challenge and review where it makes provision about you.
No, well,
Not
that-
the entirety of the report, but
That-
because
that's what
it
I thought.
made observation about you, and you didn't challenge that part about you.
Well, that's the
And
advice
that's
I
why
received.
I'm responding to the part where you say you had no locus standi in terms of challenging. You do, because the part where it makes reference to you, you could have challenged that part. Not that you didn't entirely have locus standi.
Well, first, the position was, there's no findings being made about you, firstly. It's not a finding. These are arbiter comments, right? That's the first thing. And if there's no findings against you, it doesn't affect you. The report doesn't affect you. And to the extent that arbiter comments were made about a witness, and because you're only a witness, you wouldn't have locus standi, and you don't have locus standi to try and set aside the report on that basis. That's the
But the
legal advice I
Ginola
received.
report did make a finding about you.
It did not.
The issue of dishonesty,
It's not in the findings. It's arbiter in the body of the report. It's not a finding. It could not have been a finding, Minister, because the inquiry was not about me. The inquiry was about somebody else. I just came as a witness to talk to specific issues. So the chair of the inquiry, for whatever reason, found that I'm not happy with this witness. She makes a general comment in the body of her report.
but there
Against,
was an issue that President needed to act
no,
on those.
no, not in the Ginola report. No, I'm going to get to the Concord. No, so the Ginola report is simply about a witness and the dissatisfaction of the chair with the witness. It also happens in courts where a judge can say, I was unhappy with this witness or that witness or the other, right? And then continues to give judgment in relation to those before the court, right? So the issue is as a witness commented on, can you go and appeal that judgment or review it? You can't, because you're already a witness. So same applies here, that you were just a witness, it was arbiter, it wasn't a finding against you. So there's nothing for you to challenge. It's just unfortunate negative comments about you, but they are not findings, right? So that's how that matter was left by myself. Then in the CC, the mistake, and I've got the judgment, I don't know if you have it, because I want to show you where I think the error and the confusion arose. In the CC, Justice Yakub says, of the judgment. Yeah. On page 34 of the judgment, the first error that is made is that at the bottom there you see the heading, Ginola Commission findings. It's the first error because the justice there says those are findings when they are not findings. They were not findings. You won't find them as findings in the report. Comments about me are made in the executive summary. They are not findings. So that's the first thing. And on that paragraph 50, Justice Yakub correctly says, in the executive summary of the Ginola report, Dr. Ginola said of Mr. Similane. Then on the next page he goes on. But that's in the executive summary, it's not in the findings. But for whatever it is, whether technically there are findings or not, the point of the matter is that what needs to be addressed is the negativity thereof, so that it's responded to.
That's why I could have picked up, because the Concord does make reference to it as a
Yes,
finding.
no, I understand, yeah. And as a result of that, I think the media then also reports accordingly. So Justice Yakub deals with it in that fashion. Then on the next page, paragraph 51, correctly says in the report of the Ginola, he calls it a commission, it wasn't a commission, it was an inquiry. And there is a legal difference between an inquiry and a commission for reasons that we all know. Then he copies those comments. But on paragraph 51, if you go to what is quoted there, the last paragraph, which reads, with regards to the original government submission, the issue there is that when Dr. Ginola makes the comments, she makes reference to the government submission. She's talking about the government submission. She's not talking about my affidavit. So what is the difference? When she talks about the government submission, as the DG, I'm not responsible for the government submission. The parties responsible for the government submission would be the executive authorities with their legal representatives. I'm not responsible for that, right? That's the first thing. So that's how a wrong view starts to get created, because Dr. Chinola herself makes reference to the original government submissions. As she says, many complaints were included that were far removed, and she goes on and on and on. Then she then says, this further reflects the DG's disregard and lack of appreciation and respect for the import of an inquiry established by the president. So Dr. Chinola makes an error in that she makes the government submission my responsibility, which it wasn't. It wasn't. It was the responsibility of the executive authority. So that all gets covered. Then let's deal with the specific. Yes.
Let me just reflect for a moment. In the Ginola report and in your response subsequent to that, you make a point that this is just the government submission, not yours. And you become a passive actor in the process. I put it to you that in everything that you have presented, you are an assertive, decisive person. And you said earlier you coordinated submissions from different government entities. So I would find it difficult when you say I'm a passive victim, not an active player, in a sense. So to me, I just want to come straight to your view on the issues, because right now we could be sliding towards the technical aspects of the report. Fair enough. The bedrock of the role, whether a DG or the National Director of Public Prosecution, they put the issue of ethics and integrity. And the operative term there in the NPA Act is the one to say to be fit and proper with regards to the experience, conscientiousness, and integrity. And there's a reason why for these particular roles they put the issue of integrity, of ethics, because right now we might be playing with the technical aspect of the report itself, right? So to me, there are observations made in the report about you having withheld some documents, not cooperated, not being a reliable witness. Those are very specific. Whatever technical term we can use, those were made there. And you would have said, let me challenge that particular aspect in a report because it impugns your own integrity. Would that not be the case?
You are wrong on a number of fronts, Professor Figin. There's no technicalities that was getting into. And I resist your temptation to want to avoid the issue, because I want to make these issues that Dr. Chinola raised an issue for you as this panel to think about. So I'm not going to accept your characterization of the issues I want to raise as technical issues. I'm not going to accept that, because if I accept it, what's going to happen is that this issue remains unattended, and it's been unattended for 18 years. So I'm not going to allow you to go that route. That's the first thing. The second thing, that I'm not sure where you're getting this expression passive victim, because I never said that. So I believe that let's not do that. What I'm saying is the submission of the government submission, the filing of the government submission to Ginwala is a responsibility of the executive authority responsible to make that submission. That's a legal issue. Who has responsibility to respond? It's the person responsible for that. In the same way that the minister currently should be responsible for the substantive work of the Madlanga Commission and the Khampepe Commission, as far as representing government as the executive authority, not a DG who is a functionary administratively. In the submission, contribution to the submission, I was definitely an active player because, as I said, Sue, I don't know if you heard me, as the DG, I was making contributions in relation to the issues that affected myself as DG and as head of department in relation to the NPA. So I made those contributions in that particular submission. Similarly, with the inputs from the international relations officials of my department in respect of mutual legal assistance, I provided that information to the legal representatives towards the submission. So the submission contained that information. So I can't be passive under those circumstances, but I'm contributing to it. Now, once that is done, the question is what then happened? And what happened thereafter is that the executive authority and their legal representatives then finalized the information and finalized the submission to their satisfaction. That process does not involve the officials, and it didn't involve me, despite having contributed to it.
Let me come there. Understanding the role of the accounting officer, Advocate Similane, I do find it a bit odd, unless if that minister acted, because the director general in a department is the advisor of the minister. They, like the same, where the minister becomes an advisor, or you call it a counselor, to the president.
Yes.
Now, you are saying this work excludes you. It's that of the minister. It was the minister working with her advisors. Is that what you are saying?
No, that's not what I'm saying.
Okay.
I'm not saying so. There were two processes.
Okay.
The first process is first compiling everything that's there. Government must make a submission. Everybody that knows something, bring whatever you have. Got involved in that. As part of that, I coordinated that. Everything was put together. We have these regular, it was more than one meeting of officials together with the lawyers. How do we frame this submission?
And justice is the lead. Because if there's a coordinating, for example, it takes the format of in ministers, it will be an IMC, where then the minister who chairs that, because there's always a lead department. So in this regard, you'd be the lead department as justice.
Yes,
to
because,
coordinate all this information.
yes,
to
you become lead
collate.
department because the inquiry is run by the department.
Yes.
As you know, Minister, all
Yeah.
inquiries are run at justice. They can't
Yes.
be at Home Affairs. So it follows, as a matter of course, that the lead department and the lead minister would be the Minister of Justice. It's just the way it is.
Technical point of
And
view,
then technical
it's
point
you
is the
who
Director
becomes the
General,
lead.
yes.
Yes.
Yeah, so the Director General facilitates at official level everything that's needed. So that's the role I played. Yes, and got everybody together, make sure that what was needed, they come with. So I talked to the other officials, make sure they bring the information and that they come where they were required. So all of that I did. So I was leader of the officials of government towards that particular
Okay.
process.
That would have led to what the minister will dispose of or deposit. Because you'd collate all this information, the minister will sign off what you are providing to the minister to deposit to the commission.
No, we'd give it to the state attorney and the legal representatives because they needed that to start drafting. Yes, so we'd give it to them, and then we started the process of drafting. So the draft, in other words, indicates that this is how they propose. After taking instructions, this is how they propose to do the draft. As officials, is this correct? Is this not correct? Is this what happened? Is this what happened? And then they did it. Then they finished with the draft. Then they indicated that we will now leave with this draft and go and take further instructions around finalizing it. So the question was, is there anything else that is needed from the officials? And the answer was no, and this would be finalized. But I was in the process of, basically up to a draft, I was involved in that with the officials. We were involved, yes.
So the minister finalized alone without your advice as the accounting officer?
No, remember the advice is contained to say we as the officials believe this is the best way these issues can be presented. Then the ministers and the president can then finalize however they want to finalize. But by the time the lawyers go, they've already taken our views and they've already indicated this is how this thing should be basically handled and submitted. So we would have made a contribution. So clearly I'm not passive in the way
No,
that
the issue
things are
is
suggested.
coming to, because maybe I understand, that's why I want to be clear, because maybe I would be operating differently as a minister, because there's nothing I would do without my director general,
Yes,
nor my department.
yes.
Everything that I need them to give me a go-ahead, that this is accurate, this is, if they say no, I would not sign. So at this point, there's information going to the inquirer, the Ginwala inquirer. You are collating information. And I'm linking it to what Ginwala says is insufficient information and how you would be linked. Because you are delinking yourself to say, if there's insufficient information, that would be the executive authority, not me. But I'm arguing that the executive authority's ability to be able to submit sufficient information, it will be because of you. If there's no sufficient information, it's the Director General and the officials in the department. Unless if you are to say to me, no, no, no. At that time I was on leave, there was an acting Director General who then had to do this work. But if you were in office, that's your duty as a Director General.
Yeah. No, it didn't work the way you are describing it. Definitely putting together the information towards the draft, all the officials were involved. I was part of that process. The legal representatives they produce a draft and we discuss it that this is what is going to go there. Does it reflect the views of the different departments? We all confirm that is what it will review. For in relation to myself, these are the issues that concerned me, for argument's sake. And the others would do the same. Then the legal representatives would then say, we will now go and get further instructions on this issue and we'll finalize this document and then it will be signed off and submitted accordingly.
My argument, Advocate Similane, is that your role, because you're advising the lead ministry, doesn't start and end with the department, because it's a submission that is overall. If the executive authority, that is the minister, it was not different ministers that were submitting. If it was different minister, I would understand. But here you have one minister who is submitting to the commission. Then your role will be to include the department, but also to oversee overall as a counselor of the minister to ensure that what the minister submits is accurate and complete.
I'm not sure where we're missing each other, Minister, because what I'm saying is that the legal representatives on brief indicated that based on the terms of reference, the submission is just supposed to be a submission. So that submission was prepared and it was submitted. There was no issue there. We're all involved in that. I was involved in that in the draft. What I wasn't involved in was its finalization and sign-off, because that was done with the lawyers and the principals. But the draft that went to the principal to say, as officials, this is what we believe should be submitted, subject to the principals adding whatever they want to add. This is it. You know, that's basically what went. But when it went, it was at that time that these outstanding things that the other side needs to be attached. And what I'm submitting here is that then got done as part of the discovery process. So by the time the Ginwala hearings commenced on day one, everything that Dr. Ginwala says was not disclosed was already disclosed. Everybody had it. And in fact, the opinions were used in my cross-examination. The error.
Minister, thank you. Advocate Similane, so you are saying Chinwala's opinion was actually not about the content of what you had submitted, because the impression from my reading, when I was reading, it was almost like she is drawing an opinion on the content of what you submitted, not only the process. You're right. There was also the process, etc. But somewhere I thought it was also speaking to the correctness or the truthfulness of the content submitted by you.
No. Okay. Oh, sorry. Can I?
Yeah.
Oh,
I'm done.
okay.
Thanks.
Sorry. No, first thing, I didn't submit anything to anyone. That's the first thing. It was not my job. The legal representative on brief are the ones who are instructed to file. So the state's attorney filed the submission. That's the process of filing. You file through your lawyers, right? What is approved as client. Is that not so? And I wasn't client. Client was government as represented by the executive authority. DG was not client. So that was done, right? But after it was done, the other side then said, we await outstanding information for us to prepare. And that information was then provided. So the content that related to me was the opinions. The opinions were not discussed, but the issue was were they submitted. Chinwala does not say they were not disclosed. She says you did not take the advice off. And my argument is there is no legal obligation to take advice of a legal opinion, and especially when you disagree with. An opinion is an opinion.
I just wanted to paint a picture here as a political context of the time, because we might be dealing with this in an abstract. At this time, there is a move to remove the director, the National Director of Public Prosecution. It's a different process. It's a political context. Around the same time, there was a move to charge Jackie Silebi,
Yes.
who was the co-chair in your justice cluster, right?
Correct.
So that these things are not seen in abstract. I just want to ask you rather directly, was there a time when NPA, even before you joined it, experienced undue political influence?
While I was DG.
No.
Oh, in
As
my
you
time.
observe from the beginning, and the times when you were DG and the time when you were inside, was there a time, some have said state capture, some have called it different names, was there a time when you would say there was this intensity to influence the NPA?
No. The only time it arose while I was DG was in the context of this minister letter, but other than that,
No, in your general observation.
no. Not.
So there was no time.
That
when
I
they
personally
were-
observed, no.
You never observed anything? Okay, thank you, Chair.
Thank you, Chair. Advocate Similane, I just want you to disabuse me of what I may have heard. I hope that I didn't hear you wrongly. You are saying this scenario has been lingering for long and you would want it closed out. For the past 18 years, it has been hanging on your, hanging as a cloud over you, and you would want it finalized. How should I understand you? Should I understand you to be saying that you would want this interviewing panel then to come to certain conclusions about processes which were undertaken, one by the Chinwala Commission, and then two by courts in whatever way that there are errors that you are actually then projecting out of the CC judgment? And then thirdly, the third leg of it becomes the JSA process, which you would be the first to accept that it is not for this committee, obviously, to deal with, including the other two legs that I'm referring to. Are you saying you would want somehow this interviewing panel then to come to a conclusion about those issues as you raise them? Is that how I should understand you? Just for my clarity, so that I do not then sit with a worry of what your expectations of this committee is.
Yeah, I think my expectations are clearly that, well, you don't have to find that Ginola was wrong or what. What is important for me you do is that in relation to the issues you have to consider as a panel, to the extent that reliance by objectors is on what Ginola said, you satisfy yourselves whether she was actually correct or not. So for example, and that becomes important for me because if the objectors say the Constitutional Court said we are not fit and proper, all I'll say is simply look at paragraph 91 of the Constitutional Court judgment and note that as a panel we note that the Constitutional Court does not say Similane is not fit and proper because that's factual. That's factual. There's another example because Ginola said about 3 things or 4 things. In relation to the opinions, she said, you failed to follow advice. And she has a problem with it. This panel must note that a legal opinion does not bind a requester of it. You'd know that as a lawyer. It doesn't. So to the extent that an objector says, because Similane did not follow the legal advice, don't consider him, you'd know that it can't be. That must be noted, that that's actually correct. 3, Ginola says, these things, these documents, were not disclosed to my commission. They were not in the submission of government. I'm submitting to you that you should note as this panel that the things that Ginola says were not submitted to her were actually discovered and were submitted as per her directions. So non-disclosure does not arise where a discovery process is carried out as required. Where is the non-disclosure?
Thanks for
That's
that
what
clarity.
I'm basically saying.
Minister, just 1 second. Thank you. No, just 1 second. I'm interested in how you summarize whatever. It's easy to go to a court judgment and say, this is not in the decision. Whatever is said obiter may as well has been said obiter. But this is not the reasons for the order or whatever that anybody can come to. And I'm raising this in context so that members of the public should be able to understand the responsibility of this committee in context and its duty as it is intended to advise the president on the suitability of any of the candidates that we would have interviewed on behalf of the president. Now, whatever conclusions that we may reach, in whatever context that we may reach them, it cannot be on the basis of our imagination of what we hope Ginola should have said. What we can say to you is, this particular objector says the following. What is your answer? And you give us your answer as you understand it.
Yes.
And in our report, we would be able to say to the president, this is how we understood all the candidates. It cannot be, Advocate Similane, that it becomes our job then to say the objector was wrong or right. That is not our point. We gave you an opportunity to answer to the objector, and that's why we're going to give you an opportunity again in front of everybody. I think as Prof. Fikeni is going to do towards the end, to say to you, objector X says the following about you. what's your comment? If you want to repeat it, you'd repeat it. But it cannot be that the expectation that you carry says that we must actually then make a finding of some kind that says our conclusion is, because that would be remiss of us, because that is not our duty. So we cannot be called upon to make a conclusion on an issue that we are not called upon to make a finding upon. So I just thought, let me and you clarify each other on that point so that we don't misunderstand you to be saying these issues that have been hanging are now going to find closure of some kind. But what should actually worry you, maybe in furtherance of your argument, should be the fact that if the JSA, sitting wherever they are, in whatever form that they have decided to proceed, whether you believe in their process or you don't, you are their member. And the way I understand it, from the fact that you are their member and they may have started a process which you know sits in another forum in court, it would not be correct of us to make any comments about it for as long as you agree with me that that matter then remains subject to care. So to that extent, it would then not be correct for us to say whether Ginwala, whether your submissions would have been complete or incomplete in whatever form at the time, because that was not our space, neither was it with our participation. So it cannot be expected from yourselves, at least of us, to say, reach the conclusions that you just summarized to me. And that's why I was asking you, is that your expectation? If it's your expectation, what do you base it on?
Yes, it is my expectation, and you're absolutely wrong. Your responsibility as the panel is to tell the president and advise the president that, President, we looked at the requirements of the legislation in terms of its requirements. We looked at the candidate, we looked at the objections, and the candidate gave us responses. Our assessment of the objections and the candidate's response, based on what he showed us, demonstrates that the candidate is either correct or wrong, in law or in fact. Not that you say that publicly, but the president is expecting you to advise me. What do you think of Advocate Similane? What are you going to say? No, he's not fit and proper. On what basis? What are you going to tell him? That the objector had said this, and the president's going to say to you, what did he say? And you're going to tell him. Then the president's going to say to you, so what do you think? And what are you going to tell him?
That is fine.
Yes.
That is fine that you map it out. I'm saying I wanted us to be on one page of your expectation, because that's the part I didn't understand from you. So it's fine that that's how you understand it, and as a panel we'll be able to decide on
No,
it.
that's fine.
Thanks.
No, that's fine, yeah.
Proceed. Thank you, Chair. Advocate Similane, I do hope that the pending litigation that is being pursued by the JSA does give you every opportunity to get the type of remedies you're seeking. What I'm curious about, though, is that in your papers you also concede that this has caused you reputational damage and has been something that's been carrying, kind of like a bit of baggage with you for almost 2 decades now. If you sort of, and no doubt you've had a lot of time to think about it very deeply, I'm curious about what you might be thinking about, what you could have done differently. If you sort of go back and say, where could I have acted differently to either prevent or quickly remedy this thing so that I don't carry it for this long? I'm just curious about that. Any thoughts about any missteps or missed opportunities?
Well, first, there are no missed opportunities. So that's important to clarify. When you say remedy this thing, it's after the Ginwala report, what did you do?
It's open, either before the issue, after the report, after the Concord findings, after you went back to the bar and the matter started to come up, at the time that you're engaging with the GCB, at the conclusion of that conversation, just at any point, what are your thoughts about what you could have done differently?
Actually, there's nothing further to do, because I definitely engaged government to say this needs to be resolved, and there's correspondence to that effect, and that it should be attended to. So that was sorted out on that side, but nothing came of that process. So if nothing comes out of that process, there's very little I can do. So all I was then left with was, being in private practice, I then deal with the stuff that the JSA is dealing with, and that will be attended to in the normal course. But on the government side, there was no process set. And if you read the judgment correctly, judgment says that you can still be appointed, but before you are appointed by anybody, or by the president in this case, he would need to have addressed these issues as well. So that's what it means. So to the extent that this process goes forward, and assuming that, for example, my name is one of those that's taken forward, what Justice Yakub was saying in the Constitutional Court was that if anyone, the president in particular, is inclined to consider this name, he must then reflect on the issues that have been raised. And that is why I'm saying to the gentleman that that is why the president would then ask this panel to say, to the extent that these 3-4 issues are raised and they were answered in front of you, what do you make of it? And that's what this panel would give a view.
Thank you, Minister. Advocate Similane, you made a point earlier on the impact of the delays in processing this matter by JSA, that you've been sending correspondence to no avail. And you also made a point that there is prejudice that you would suffer, or that you are suffering, particularly where fit and proper is a peremptory requirement in certain positions that you may seek to, or which you may desire to apply. So is it then your view that the issue of fit and proper, which is a peremptory requirement for this position, would be a factor, as you made that point earlier?
Yes, the prejudice is not only in relation to this, it's in relation to everything else that's out there, as Ms. Manduleke indicated. It's reputational, right? Because there's an outstanding issue. But it fits in here, in that this panel can say, we'll put him forward as one of whatever number of names the panel put forward. What I was submitting to the gentleman is that this then becomes current and present in this matter, because a deciding authority would then have to say, if I am to consider this individual, what do I make of these comments that were made in the general report? And the question would be, the purpose of this particular panel is to indicate that if we are inclined to do so, in respect of these comments that were made, this is our view, because we heard and saw what the objector said, and we got the response of the affected individual, and therefore this is our view. So I would expect that yourself or anybody who's a lawyer here would say, President, nobody is bound to follow a legal opinion, especially if they don't accept it. Standard.
Should we move from this now? Members?
So how do you do that? You've got to skill the officials concerned. They're already qualified lawyers, they already know how to run cases, but they're not skilled in everything that they need. Learning is a continuous improvement. Even lawyers in private practice continue to be trained on trial advocacy. It's something the NPA needs to do. Just because you repeat something over and over doesn't necessarily mean that you are up to date. From time to time, you need to meet your peers. From time to time, you need to be trained to upskill yourself. So those things will need to be done. That is the important thing. If that is done and they understood the vision, then the external factors of influence become diminished. They'll always be there, Minister, I can guarantee you, they'll always be there. But they become diminished because what you would have built is a character of individuals that understand their purpose and they understand what they are there to do, what they are there about. They understand what is expected of them by society as a contribution. Then they resist any attempt to make their work difficult, whatever way. In the strongest possible way, maybe subtle influences, but once they know what they are there about, that gets avoided. Right? So when you do that, what are you hoping to get at the end, going forward, looking back? You want to find a prosecutor that's compassionate, that knows that we're in the business of conducting prosecution of individuals that have committed a wrong. The Constitution requires us to still make sure that that is done in a dignified way, because those individuals have rights as in the Bill of Rights. So we must be compassionate to understand that although you are a serial killer, you're still human and we'll treat you with dignity. That's at least the minimum you deserve. Equally, they look at the victims and the survivors of crime. They must be compassionate to them, understand their expectations, understand that they expect to be treated in the manner that demonstrates that there's an understanding about how they feel about what has happened to them. So which means the burden that you place on an individual that we call a prosecutor is an enormous one. And in order for that individual to be able to perform those two conflicting tasks in a way, because that individual is complying with the Constitution, that individual must be appropriately skilled, trained, and assisted to function at that particular level so that they can carry that on their shoulders. So that is the vision. So when that is done, you then target the cases that need to be targeted in their various forms. I think the annual report demonstrates exactly what needs to be done, and there are many of them. As the NDPP, what one would have done with management, deputies and DPPs, would have had as a matter of course, because there's nothing new, everybody knows what they're doing, is sit and identify that at this point in time in 2025, what are the priorities that we need to focus on? There's a lot of cases, so there needs to be some prioritization, right? So clearly, as has been indicated in the public domain, there are cases that relate to certain activities, state of capture, the commissions, GBV, rape of minors, especially statutory rape of minors, rape of adults, as the case may be. And we start working on those cases and identify where we can make interventions. And I have some thoughts about that because these are targeted prosecutions in a way. My experience, and it's part of organized crime, but others may not see it as organized crime. Supply chain management is where, in many instances, organized crime begins. In other words, it starts small, and then it gets big. It starts small with three-coach system that gets abused. It grows according to number until it runs into billions. We tend to treat that as, it's a simply PFMA issue, fruitless and wasteful, irregular expenditure, blah, blah, blah. That's where organized crime actually begins. And I'll show you why I say that. How do you get a three-coat? You go to any annual report of any department or information and you ask them to show you all the payments that have been made just below 500,000, you get them in February or January, plenty of them, right? What does it tell you? Other than the fact that they may have been dumping. It means around that time, some individuals would have sat and have used a three-code system to just stay below the radar, 499,000, 450,000, 480,000. And they do that multiple times. And in some cases, upon further investigation, what you find that it's a small group of people, but they run multiple companies, but they use the same approach. It's easy because it's three codes. So in order to do that successfully, what do you need to do? You need to have somebody that calls for three codes in the department. Somebody who says, can I have a code from you? Can I have a code from you? Can I have a code from you? In some cases, people who do that, they call people they know that it's the same person, same people who have these companies, and they just deal with them. So supply chain is an organized crime business. It is not a PFMA offense. It's an organized crime. So that has to change in terms of how it's approached. And how you deal with it is, again, not very difficult. You know why? Every year, Ms. Manulege and the team produce reports in which they tell you where there's PFMA contraventions, or at least they're suspected. So all you have to do, if I were to be appointed, starting, let's say, March, there's 40 departments in the country, roundabouts. You take all their annual reports that were just published now in August. They contain all the information. And it's useful because they contain the information that has been prepared by experts. You look at it, you start investigating. Who do you need as your witnesses to come and say, this is what happened? You go to the AG and say, the auditors that worked on this report and produced it, they have all the information. They've analyzed it. They can talk to it. Can we have them as evidence leaders to come and lead evidence to demonstrate that this is how the contravention has happened?
Wouldn't that be a duplication with SIU's work?
No. In law enforcement,
Clarify that. That's what I'm asking, because currently that's what they are referred to SIU. And I say this in the context where we are dealing with duplications, as you know. We're trying to rebuild and recorrect the infrastructure of the justice system, especially dealing with corruption.
yeah. In my respectful view, when you present a case in court, 2 experts are better than 1, 3 experts are better than 1 to make a case. What the first one in this case would be needed for is that as the Auditor General with the stamp of approval of that office, that witness would say, we have done this work and this is what we have found, and I, as the auditor, I conclude that the following wrongs were done here by the following individuals, and these are my reasons for doing so. And they'll even go further and say, before I finalize my report as an auditor, we sent the draft, we sent a few comments, and we received management comments. We looked at them, analyzed them, attended to them, and we still conclude that on these ones, there's something wrong. That's valuable because what it does, you immediately put the other side to bring their own experts, similarly qualified, to disprove that. That's the first thing. The SIU will bring another expert. If the SIU had an auditor as an expert, that auditor may need not deal with the PFMA issues because the AG auditor would have done it. That auditor may deal with something else, financial information and other things. So there won't be a duplication necessarily in that way. So that's how you split your experts in terms of the point to which they talk.
The issue why I'm raising duplication is because you spoke about if I'm NDPP, I'd bring the investigation. And my issue is that, but currently, that's what SIU investigate. I'm not saying NPA does not have a role, because currently as SIU, as AG does the reports, refers to SIU, SIU then does a further investigation and concludes, and then hands over those cases to NPA. And what I picked up was almost like a change of this process. Is that my correct understanding and reading of what you said?
No, unless I wasn't very clear. In my respectful view, there'll always be a difference between what the Auditor General stands for. Tactically and strategically, what you need in court for the Auditor General is the stamp of the office because it carries power. So if somebody is a credible witness from the AG's office, concludes in a way that is not refuted, that's a slam dunk case as far as PFMA contraventions are concerned and those criminal offenses are concerned. That's done on its own. What the SIU side does, the SIU goes further and looks into other things. So that can relate to other charges. And in respect of those charges, they'll have their own expert witnesses to attend to whatever they need to attend to. And I believe this would even help in the sense that PFMA charges stand on their own. So if you want to create a culture of compliance, I would say let's just start with those. Even if you're investigating corruption as well, continue investigating it. But in the meantime, if we can prove fruitless and wasteful expenditure or irregular expenditure, we get it done and dusted and we get a conviction. Even if it doesn't, in fact, I think it, depending on the amount, I suppose even if the amount is a little bit high, it may not necessarily require a custodial sentence. It's enough to get a suspended sentence. But what we got is a conviction. That's what matters. Because by the time you appear for corruption, fraud, and theft, you're already a convicted person, which helps in the context of sentencing, because you are then able to say to the presiding officer, this one was already previously convicted. And that changes the game altogether. And nobody wants to be taken to court to be charged and stands a chance of being convicted for the second time, because they know that sentencing gets worse if you're still within the suspended period. So that type of targeting of prosecution, in my respectful view, is important. But there's another side that is not always thought about. The BBBEE Commission, where fronting is criminalized. I don't recall enough cases being looked at. Maybe it's because there isn't enough fronting. But I would imagine that where you have a body that conducts investigations of that work already, and they produce a report in which that body concludes that in this matter there is fronting, there's very little further investigation to be done by EDAC if it's EDAC or the DPCI if it's the DPCI, because experts in the field in that organization have already got the reports that says exactly what you need. You clean that up, you go and prosecute that, and you get the results. And the impact of it is that once you get a successful result on fronting, you deal with the systemic issue of fronting generally as a whole, and you assist small business to partner with people that truly value their skills as opposed to people that partner with them for purposes of renting their skin color. That is important of dealing with it. Thirdly, the Competition Commission amendments were made a couple of years ago where certain behavior was criminalized. Collusion, certain restrictive business practices, abuse of power. I don't remember a prosecution being run on the basis of a concluded investigation by the Competition Commission that abuse of power has been run. So the point I'm making is that we already do have bodies with qualified experts that do the actual work and produce the content that's required. But for some reason, we seem to be missing that. It may be that because of the volumes of other matters, it's an issue the NPA sees a little bit further down. But the impact of it is important. It's economic. It affects small businesses. Yes, it affects big businesses, but the biggest beneficiaries of success in that area are small businesses. The PFMA issues deal with governance and conduct within a department. You can even go further than and go to a municipality and go to an SOE, as the case may be. But if you just start in a department, you're done. In that you begin to create the culture that you need that changes conduct. If you change conduct in the department, the outsiders who are coming in to exercise influence start finding resistance, because these people here on the inside know that when our report comes out, there's going to be a bunch of guys that are going to look at the annual reports and start working on it, and we get implicated. It's that simple, amongst others. So for me, it is that.
Advocate Similane, just
Yes,
a
ma'am.
second.
Thanks, Advocate Similane. You earlier raised issue of skilled, trained, and targeted
Yes.
interventions. Now, I just want to know what additional skills, I hear you that from the respective areas of focus, there would have been foundational work and outcomes secured, or at least suggested, that would go to the courts. But inside the NPA, because throughout these 2 days, we've been hearing how there are limited skills. So what kind of skills would you bring, for example, for people to be able to take the AG report and go and prosecute on it and argue wrongfulness based on the information provided by the AG, or argue collusion based on the report provided by the Competition Commission?
Yeah. I think it's important to always not take only the version that says there's a shortage of skills. Somebody must be able to say, what skill are you talking about?
That's
Yes,
my
I
question.
understand as a
Yeah.
question, but somebody who says there's no skills, they must tell you, what are you talking about? What skill do you say doesn't exist? Excuse me, but typically in the NPA, the most important skill must be the ability to present a case. So trial advocacy is important. And there's different levels of it. Basic, elementary, depending on the level of prosecutors. The more senior they are, the more experienced they are, the higher the advanced advocacy training requirement would be needed for them, firstly. Then there's also financial training, the ability to read financial documents. There are people, maybe us around the room, who may be qualified, but we may not be able to read a balance sheet. Give somebody a balance sheet, they don't know what it means and what it represents. And they may not be able to find a crime right in front of them because they just can't read a balance sheet. So part of the training would involve financial training, reading balance sheets, being able to understand things. Share price manipulations. Find somebody, for those that deal with a lot with fraud, commercial crimes, find people that provide specialized training to be able to identify share price manipulations where information is given. So in the NPA, we'll be able to look at the gaps. So when you look at the cases where there's successful convictions, others where they are withdrawn, others where they are struck off the roll, and they're going nowhere, it's important to sit and understand what's missing in what was withdrawn. Why was it struck off? What's missing? Fine if you can't find a witness, that must be found. But it can't be that we've got 5, 10 arch-level files, we just don't understand them. We just don't understand them. What do you mean you don't understand them? Read them. We've read them, but we're not sure where the crime is. That could be an indication of a deficit in ability. And once that's identified and people are skilled accordingly, that gets done. To be able to find people that hide assets in trusts, in whatever other instruments that are utilized. And knowing that people actually do that, as many do in the public service. They declare and make it very clear that I'm clean, I don't have all of this. But a further check by those that are skilled and trained in that discovered that the bugger has an offshore account, that type of thing. So that type of identification of skills required starts with a painful exercise of going to look inside the organization, those that are struggling. Sometimes it's easy, you can go to court and witness it yourself, but based on the statistics that come out, and you start engaging with the DPPs to say, why is there prevalence of withdrawals in your case, or struck-offs, or lack of meeting the target as far as convictions are concerned, you'll then discover this. But my sense is that if you speak to people honestly, and they don't fear reprisal, punishment, and judgment, and that type of thing, people will tell you what they need. They say, okay, I think I can talk, but I can't write. So I need training on writing skills, because many arguments are won on paper based on how well it's written. You can be articulate, but if you've written badly, decision is already made. For other people, it's vice versa. You find that can't write to save their lives, but they can speak themselves out of any situation. Not one of those, but that definitely does happen. So you've got to look at those things, identify them, and skill them appropriately. Then you can even go overseas. It really just depends. And if you benchmark, you know what level people, somebody at the level of a director, you should know, you should be skilled to this capacity. At a chief director, you should be skilled to this capacity. Entry level, the minimum is this. So that's important. Then if you target, you can go as far as you go in the sense that you can target really basic things that everybody speaks about, means sitters. Every year for the past, I don't know how many years, we're always talking about sitters there. So we may need to want to look at that to say, let there be a team that just focuses on SETA, and it depends on which one. SETA as in the training authorities, but SETA, the institution, the information technology institution. It's been a problem for people for years. All that I'm saying is that at the end of the day, it has implications for work. Is there sufficient human beings now to do the kind of work we're talking about? And I think there's a big risk in being all over and taking too much. One typical case that we can all identify with, but I wondered the other day if we think about it, the Meiwa case. For how long has it been running? That long. It's one guy, Minister. It's one guy.
8 years.
No, I have a number of years. It's one guy running it. Well, I'm saying 8 years. 8 years, yes, indeed. Advocate Balo has been running that case by himself for 8 years. He comes tomorrow, he says, I can't take it anymore, burn out. The case is not finished, it collapses. And yet it's 10 years late in the system. It delays further. So in all of this, with the menu of things government mandates the NPA to do, there's so many resources. So issue of resources would have to come in. So state of capture, then you add Madanga Commission and all of those type of things, and the Madanga Commission will have rollover of things. There is no way there cannot be a discussion about the number of human beings needed to come to attend to the problem. It has to happen. And once you bring them, you can bring them already skilled. They tend to be more expensive. You can mix, bring a few that are already skilled. They tend to move much faster. So they can do in a month what others would do in 6 months. So you need those. There's no doubt about it, even if you have to bring them in from outside. Find the money, attend to them. But you've got to build your triangle so that the bottom has a lot of people, pay them adequately. But you know that at least I'm going to lose 16 months, because to train them to be able to be proficient can sometimes take that long. So you need a bit of patience. But it may start slow, but then going forward as they acquire the skill, they then move a little bit faster.
Are you?
So that really is the kind of vision. I could cover other areas that I think are important. One that I noticed that I found strange when we deal with corruption is, and I can't understand the choices that have been made and what it means. There's been a talk of amnesty for the past 2 years, 2.5 years, even more in the shadows.
Amnesty of?
Amnesty in corruption matters. There's a number
Where?
of people.
I've not heard it.
No, Minister, it's been a discussion going on.
I'm in the wrong circles then. They don't include me
No, that
in
are
those
the wrong
discussions.
circles. No, there are people that have thrown suggestions for quite a while to say the problem of corruption and state capture has been so big and so much money lost that what if there was a general amnesty in the country around corruption, provided people brought in the proceeds? Is that palatable to society? Is that something society would be willing to consider? Those who are proponents of that approach suggest that we've gone just too far down the road. The only way out is to undertake that people won't have the negative consequences that they fear, but we'll get back a portion of what we lost, especially money, even if it's offshore, and we start afresh. It's that kind of approach.
Are we not having enough tools to be able to get that money, even if it's offshores? I thought that with the availability of the work that is being done by AFU, FIG, and others, we could, if we rather have the right people to drive that, instead of, because I know you are saying it's what is being discussed, and I'm exploring it because I'm hearing for the first time almost. Wouldn't that be seen as also encouraging corruption? Because I always say corruption is not a victimless crime.
Absolutely.
It's got victims.
Absolutely. Yeah.
And in our system, then what do we do with the victims of that corruption? if we do the amnesty. I mean, you'd know we have a situation with the TRC Commission where the victims are saying there's no justice. Until people are prosecuted, they can believe that there's justice. Wouldn't we face something like that, as we think?
That's the yes, that's exactly the counter argument to it, to say, no, maybe hang on, that may not work very well. And I think that discussion hasn't sort of gained momentum, and I think slightly for that caution to say, what will it look like we are saying, to people? But it was definitely floated. A few individuals definitely floated it, seeking to influence the process. But the reason why I'm raising that is that there has been, and I think it's worth looking at, where in the NPA, one or two companies have come forward and returned money on the basis that there's a no guilt arrangement, but also that they may not be prosecuted or need not be prosecuted. There's a problem with that. Because what is that? What framework is that? I personally, when I can't even remember the term used because I don't understand it. I've never heard of it. I know plea and sentence agreements, but I don't know this one where it says we'll have this kind of arrangement, bring it back and whatever. But there's merit in looking at what was attempted to be done. It may have merit and it may be explored further and it may be a solution, because the first prize is just taking that much longer and the menu keeps growing bigger and bigger and bigger. And if there's not enough resources to feed the system, bring in people and naturally technology to deal with these things, which is an inevitability, it needs to be done. If there isn't money for that, then there must be pragmatic interventions at some point about what we do, where. So the NPA can play a role in that by indicating what it can do and what it is finding difficult to do and what it completely cannot do and what it needs to do. Similarly, it goes to the police and so forth. The problem that we'll experience with the two commissions that are prominent, that make it that much harder to look at the work, is that it's exciting to have a confession, to get told the truth by the confessor. The problem, can't use it. Can't use it. Come and confess and tell us everything you've done, Gori, you name it, can't touch it. It's inadmissible. We still have to start afresh. I suspect that's why in some areas it's taking longer. So I would not blame the NPA, and I've defended it in various fora, that whilst there may be legitimate criticism in respect of the current NDPP's work, I think people are misunderstanding the difficulty of having to find some of the information while everyone is aware that that's the person they did it. The only reason they're standing there is because they confessed it. Otherwise, we know. So the NPA needs to come out and say, in respect of these cases that are standing still, the problem we have is basically this now. Because the frustration of the public is that with everything that we've heard, we don't understand why you can't move. It's because we can't use it, but also because we have to start afresh and dig it, which was always the issue with the SIU minister, in that they can conduct all investigations. You still need the DPCI to start and conduct an investigation. You still need EDAC to do that kind of work. So corporate prosecution side of the system doesn't look great. It does not look great. If you go to 2010 Stadia, there was deep collusion, deep corruption, a municipal manager dies for whistleblowing. What happened to those companies? What has happened to that case to date? It's 14, 15 years later. You move on to others accordingly. So those issues do matter, Minister, other than the usual cases that we all tend to talk about. In fact, here's something important that I thought I saw. A couple of months ago, I saw an article that said KZN last year had about 10,000 children giving birth under 16 or under 18. 10,000 children delivering children. I would have hoped that, and it's not only there, I think there are other jurisdictions, but the number, I thought KZN.
The highest is Eastern Cape and KZN.
Eastern Cape and
is the
KZN.
highest.
Yeah, I looked at this and I thought, the kids are delivered. Somebody should know who the father was. So depending on age, I suppose the younger they are, they may be unable to identify the culprits as quickly as possible. But I'm imagining 13, 14, 15-year-old can say it's so and so. That becomes a person of interest, at least at a minimum. Without exposing the identity of that person, the person gets engaged to say, this is what we have, submit yourself to a DNA. Nice, quiet, you don't have to besmirch your name in case it goes wrong. You work with that environment, it's managed quietly. You get the DNA. If it's not the person, it was quiet, the person was never exposed. Must be handled sensitive. But if it's the person, you've got your culprit. I don't know how long forensics takes these days. But
Is there a quiet process?
no, there is, Minister.
Because I deal with litigation of the state, as you know,
Yeah.
false accusation and all those things, whereby the minute you say a person, then they say no. I had to explain to my wife and my family why I'm going here. I was asked, and therefore there's implication, and legally that person can take us to court.
Well, either way, whether you do it quietly or not quietly, you'll end up with that scenario anyway. But what I'm trying to suggest is that...
That's what I'm saying, why quietly?
Well, in the sense that you may find people that don't want their name associated with that. To come and sue later, it doesn't sort you out, Minister. You can say, look, I was wrongly accused, I sued, I got 300,000, so you're still the guy that, you know, once the damage is done, you can't fix with money. We're not like America where at least you get millions. You can go hide in an island. Here in South Africa, you get 50,000, and the best you can get with that is what? Tickets to a suite.
Okay, I would like to move to the next segment.
Yes.
Because I think we've gone in detail in terms of what you see as the work that needs to be done. And I want to open for the panel in terms of their questions, and then end with Prof. Somato Tafikeni with taking you through the comments. Just to check the side, any other question? Okay, from here, you've got advocate.
Yes,
Proceed.
Minister, it's just a small one. I would like to know your opinion on laboratories, because forensic laboratories are the biggest hold-up for and whilst you are there, also maybe just club to Zella care centers there. We've got 66 of them now, and no very limited funding from government. Just briefly.
Yeah.
Sorry, Minister, I'm taking time asking.
But DNA is the responsibility of police, but we do work with that, but it can go on.
Okay, all right.
Yeah.
No, I can withdraw it. It's just that I think. Okay.
That issue's been there for a very long time. Now, how many labs must you basically have? Ideally, a dreamer would say a province, there must be one, at least a province, to focus on those statistics, you know. But others would give you better to say you don't need 9, you may do well with 5 or 6. We don't know what the holdup is. The police will explain. It may be an issue of resources, but there must be a way in which that is identified. It's either it's money to have them and equip them, or if the money is there, it's finding the people and having them appropriately trained to deliver. But there must be an answer of some sort. It can't be an issue that gets discussed all the time, because the numbers we've discussed about these kids, those are the victims the minister is talking about. It's 10,000 victims waiting for justice. And if you deal with 1,000 of them successfully, the another 9,000, you can't. Then they go back to school. You know, whatever the numbers may be in each province, that's a problem. So that's the first thing. Tutuzela care centers, I suppose, will always be a money problem, in the sense that to create it, it's a model that is great, that's excellent, it works very well if it's functioning properly. It delivers. But it's a luxury right now, because in terms of the numbers they deal with, they are a pittance compared to other numbers out there. They remain not as accessible as they can be, as they should be. And the only hold-up is money. And somebody else would say, if you sorted out the labs, you can get more numbers done than in a Tutuzela care center. But the problem is that a Tutuzela care center is advantageous because you have more of a skill set and you have an approach that manages issues in the best way possible. So money, yes, is a problem. Thank you, Minister.
You can proceed.
Thank you. A quick question. So what are the top 3 things that diminish public trust in the NPA?
3, first one is not knowing what they do. Just have no clue what they do.
Huh?
Well, not me, I know what they do, but I'm saying the public doesn't know what they do.
Oh, okay. I thought you were saying NPA colleagues themselves don't know what they are doing, Advocate Similane. I was like, you.
No. No, those ones know very well. They know very well what they're doing. I think the first problem is the public just doesn't know what you do. How do you make decisions? The choices that you've made, how do you make these choices? Choosing this one and that one. So 2, it's the lack of transparency. Decisions tend to be made quietly in a closed group, collegiality. That's just a issue of habit. We need to be more transparent and be more engaging. When the NPA communicates, it doesn't communicate the detail that it needs to communicate that builds confidence. And that may need to change. Yes, it's important to let people know that the case came to court and left and the matter is postponed or withdrawn, whatever the case may be. Maybe a little bit more explain why is the matter postponed for 6 months, because that's the next date, purely on the basis that for some reason somebody could not arrange a foreign language interpreter. How did that happen? We're losing 6 months because an interpreter couldn't be found. And yet when the matter was postponed to that date, those involved knew that when that date comes, an interpreter, foreign language, would be needed. So why is it that when the matter comes, the issue of a foreign language interpreter was it deliberate to create a further delay, or something fell between the cracks? Are there no partnerships? In my time with Justice, we had an MOU with Pansal to say, can they build capacity to be able to provide different foreign language skilled individuals that the department could borrow from if they were needed in court, as the case may be. So those things, they're not soft, because I know people tend to say communication is soft. It's actually very strategic and very key. So I won't use the word soft, but for me, those are the most important. When people get to court, ma'am, they come to court, they hear the matter is postponed, and they loiter. You can see that they have no clue what just happened, unless somebody goes to them and sits down with them and takes them through. It's postponed for this reason, especially in cases involving violent crime, let alone rape and sexual assaults, or GBV as the case may be. So that becomes very important.
Anyone from the 2 colleagues? Mfundisi, Prof, I hand over to you for the segment of public comments.
Well, thank you very much. 4 hours later, we're almost there. This last part, Chairperson and colleagues, the nice thing is that we front-loaded those, because it's mainly your comments received from 28 organizations and individuals, mainly individuals. Then 2, which I should start with, were in support. One being the Deputy Secretary of NAHAU within the Department of Justice, and even saying that he wishes that you had to come back as a DG. Then you also had another individual who indicated that you have depth, experience, resilience, and institutional knowledge that you'd bring. But then the balance of the comments have generally been objecting.
Yeah.
And in the objections, they referred to the Ginwala observations on your character and integrity. The issue of integrity keeps coming again and again. Some implicates you in the role of capture, state capture. Of course, they tend to put it in broad terms at times. And of course, the media generally had raised those issues as well. And they often cite the Constitutional Court. Some, of course, saying that Constitutional Court finding against you, but others accurately saying that it was on the president having failed to look at the Ginwala and take that into account as you were being considered. Then we had one from a former NPA member who indicated that he's now retired but objects and go on, you must have received the documents on the specifics where he's objecting as to why and what conduct there was when you were there. But the bulk of them, which is something that I would like you taking others, of course, into account because you were given a chance to respond to them. You gave a very extensive response. Most of them talks to a very fragile NPA that is struggling to reposition itself. Then they say you have these many pending cases, unresolved issues, which by your own submission and presentation you have also indicated. They say almost this would squeeze the very oxygen from an entity that's trying to rise should anything happen on the pending cases. What would be your reflection to that? Because in essence they say in a hypothetical situation you were considered. You have to deal with these pending matters unresolved, and this forum, as it was indicated, can't resolve those. And then there's NPA that also is facing major hurdles that it has to deal with as a repositioned organization. How would you deal with that recurring concern? One, integrity, the other one, the one of the reputation and the reputational risk.
Well, I think thank you. I've demonstrated to yourselves instances where that submission has no merit in relation to Ginwala. Just basic, at a common level. Non-disclosure is a non-issue because there was disclosure in the way that legally it's accepted. Discovery process, it's done. So that takes care of two things. It takes care of the letter. It takes care of all the other attachments. Opinions, no obligation to follow them. That takes care of that. Accounting officer issues. The head of department is responsible for the relevant issues, as the accounting officer is responsible for the finances. And the issues that Dr. Ginwala was relating to are issues relating to the responsibilities of the DG. Those three fall away. So there's no merit as far as that is concerned. So this shouldn't recur. Whilst this panel doesn't have to make anything public, what I'm trusting it will do is to advise the president properly. The issue that is sub judice is the one that remains outstanding. Can I respond to the issue of the arms deal that I was informed. I don't know what Advocate Cronje
Before you
said.
move that one, you're saying which one is sub judice?
The JSA one.
The JSA one
Yes,
was
it's in
first,
court.
just to be clear, first they found you
Yes,
guilty
they
and then
did
you
find-
appeal.
Yes, there's an appeal, yeah.
So there is an appeal, but they have already had one. I wanted you to deal with that because it wasn't clear that
Yeah,
it
they
was
didn't
as
deal
if
with the appeal at all.
they haven't.
So what they
dealt.
did instead, they just moved. So the appeal remains outstanding, and while it's outstanding, they just move for a strike-off. So the issues before court are sub judice in the sense that they will address these types of issues, whether
Okay.
what they've proposed to do, they'll do.
No, I wanted to be clear.
No, absolutely. The issue of the preservation order, can I deal with it because it was suggested? And I'll deal with one or two other cases. She's correct. That got done, Minister. We did that. No, that got done, Minister, and it was done legally so. And I would have expected by now that if anybody felt that anything unlawful was done, they'd have gone to courts to challenge it. What had happened again there, we have two things. We have the arms deal criminal investigations that were going on the side, no problem there. Those continued, they're not the issue here. But the individuals was also subjects of those criminal investigations. But then there was a preservation order on a bank account that he held in Switzerland. That's what the preservation order was, on the basis that it's unexplained income. Nobody knows where it's coming from, so we're holding it. So his legal representatives, Advocate Celias, SC, and them wrote to the NDPP to say, there's a preservation order and we're making representations, and we argue that there's no basis. And they submitted documents to that effect, and they asked for, again, a meeting to have that discussion. So documents came in advance. Archlava files about 2 of them or so. I looked at them and I said, okay, the meeting can take place. But I then asked the head of the FU, Mr. Hofmeyer, that we discuss this, which we did, and we agreed that we would meet Mr. Silas. They would bring the team with. Advocate Cronje wasn't there. So if she said anything here, it's obviously hearsay. But I don't disagree with it because it factually did happen anyway. So we had a meeting and the legal representatives came and the team sat like this in a boardroom and received a presentation. And
This team involves as well the head of FIU.
AFU, yes, yes, it was there.
AFU, which was leading.
Yes, it was
this
leading. It was
matter.
me, it
Okay.
was him.
And
I
then
think
from the
it was another
province that
deputy.
was dealing with it?
It was
Well,
Gauteng. It was this one.
It was
Yeah,
Gauteng.
it was
Okay.
this one. So it was an HQ matter. So, and then they called other prosecutors who were dealing with the broader arms deal criminal investigation, just to be present. So it wasn't an issue. So they were all there, close to 10, 15 people in a room. So they came and then they gave a presentation why they believe that the preservation order should not be taken further to a forfeiture order, because that was the next step that was gonna come. So the official said, well, we haven't seen some of these documents, we need an opportunity to look at them. So I said, look, thank you for the presentation. Leave these documents, we'll discuss them internally, and then you'll be advised accordingly what the attitude is. That was done, and then I took those documents and I said to the colleagues, I'm gonna make my own copy, and I'm gonna send these documents to everybody else for everybody to have their own copy. Then we'll meet to discuss. The following week, we convened. Everybody had read, we sat, and we had a discussion. What is the issue here? The issue is we don't know where this money is coming from. Okay, how far is the investigation going? Investigation is going. The preservation order is gonna come to, is gonna reach its time frame. Preservation order is a couple of days, I think 90 days or so. And if you don't extend it, it lapses, that kind of thing. So we started having a discussion about this thing, and I said, let's all discuss, because I must respond to this, so let's all discuss to finality. Everybody's at time, let's now comment. We went back and forth, back and forth, back and forth, back and forth, back and forth. And every time we went back and forth, we kept looking at the document submitted. Then the numbers started changing. You know, it was majority, no, let's extend it. Minority, no. Then started moving. Then I asked,
That
the
moves
number
from-
of those that were advocating for preservation order to be extended, and others were saying, let it lapse or withdraw it. Whichever one you want to do, it's your decision. Because they were not so sure anymore, right? There's a lot of information. Then in the documents, I drew the attention to a contract that was there. Said, as everybody looked at the contract, and others said, yeah, we've looked at it and all that stuff. I said, what do you think of this contract? Say, yeah, it's a contract between this individual and these other parties. Okay, I mean, have you read what it says?
What's the parties in the arms deal?
Yeah, well, in respect of just these two parties, the individual whose account was blocked, and another party, they had their own agreement. Yes, it's part of the arms deal. They are in this agreement. So in this contract, they agreed on certain services. So that's fine. It's not an issue. But in there, and nobody had an issue with those things. So we say, so what does it represent that there's a contract? Is it legally binding? Is there anyone with evidence that this contract is not legally binding, it's been set aside or whatever? Because as it is, it's legally binding. We debated that. The conclusion was it's legally binding. So, okay, it's legally binding. So what does it mean? We look at it, say, well, it's legally binding. Then somebody said, yeah, the amounts involved, they were not indicated in the contract, but a commission was indicated. Said, okay, there's a commission there, okay. So it looks like the monies came from this, based on this contract, which is what the parties had submitted in their submissions. That it's this contract, the basis on which the commission was paid and the parties were paid. So is there anybody here that would say it's unexplained income? So nobody could. Everybody accepted that. No, that explains it. So if it explains it, is there a basis to hang on to the preservation order? Because it's been explained. What do we do? This is what the parties have said. How do we respond to this? Well, you can't explain. So the long and short, the conclusion was, well, because the matter of the corruption on its own is still being investigated and there's no conclusions and there's no link to this particular individual, we can't say that this individual is still part of, or is part of that corruption investigation, but that this individual has given an explanation which, on the face of the documents provided, there's no counter-argument that we can rely on. On that basis, I then indicated that, well, if that's the case, it looks like it's going to be very difficult to extend the preservation order. It may very well be withdrawn, and that's how it was withdrawn.
It was a team agreement. But
It wasn't a
will be
team.
withdrawn.
Basically, they said it wasn't an agreement, a team agreement. They said, we understand, we see it, but it's your decision as NDPP. Then I said, I have no legal basis to argue if I don't have information.
I'd taken over from Prof. My apologies.
I'm not going to start anything new. It's just the completeness of record to say that the Labour Federation, COSATU, also objected, and the Freedom Under Law also objected. Active Citizens Movement also objected in addition to that. And also another part is that the Public Service Commission has also been used as a reference point for the findings. But in this case, it can't be your fault because they were asking the executive authority to take an action against you. And if the executive authority didn't at the time, so it is just a list of things that they were referring to, all arising from the Ginwala matter and things of that time. It's just for those following the proceedings. Minister, thank you.
Thank you, Minister. On the Public Service Commission, if I can close that loop, it's not entirely complete, Prof, because the Public Service Commission, the problem with that investigation is that they also never spoke to me. It did what they called a desktop investigation without speaking to me, and then by the time it was produced, they had a problem because I was not given Audi, and that's how that matter ended.
And did you challenge the report at any stage because of that flaw?
Of the Public Service Commission? No, I didn't challenge it, no.
Just something from my side, Advocate Similane. On your response to us dated the 8th December, there's an issue that you flagged there in relation to Terrell Blanche, Eugene Terreblanche matter.
Yes,
You said.
on the 8th of December,
Do you have the copy?
yes, I have a copy of the document. I remember the Terre Blanche
Yeah.
matter, yes.
This one you are responding to, I think you are responding to a comment. But I do find something in it that I wanted to talk to you about.
Yes, paragraph 5,
Paragraph 5.
yes.
In there, you talk about, as the NDPP, identifying a prosecutor in the DPP's office in Pretoria who'd attend on the bail, but also yourself as NDPP, traveling to Ventersdorp and personally meeting the families of the deceased with the prosecutor, but also in terms of an African minister, I think here, who had instructed to speak to the family in Afrikaans, and also the language, you highlighting that he did and the family. I also addressed members of the AWB who had gathered outside to protest.
Yes.
I go back, where is your DPP at this point?
Oh, no, he was there. He was part of the decision. He actually is the one who indicated the best person to do it.
He indicated?
He indicated the best person who would do it. The issue was, when we're in a meeting, when we're discussing the case, and the issue was, how are we going to approach what was likely anticipated would happen there in terms of protest and so forth, right? And the suggestion, even from the DPP, was that, can you as the NDPP go and assist so that we can quell whatever volatility that may have been there? Then I said, no, that's fine, I'll be happy to go. But I don't speak the language. Do we have people here that speak the language? And he indicated the officials, and one of them happened to be African. Then I said, okay, why don't we use this one, you know? So he said, no, actually, this is the perfect one that you can take. Why don't you go together? So he assigned that particular individual. It was the
DPP in Northwest?
No, not Northwest, here
Gauteng.
in Gauteng.
And where is your DPP prosecution?
He was around. He was around. I think it may even been him, but he definitely was around. Yes.
This intrigued me, and you'd remember previous as well.
Yeah.
You spoke about the police and how the hierarchy works in NPA.
Yeah.
So as I look at the comments, I think I missed it. I would have raised it earlier on.
Oh,
As I look at the comments and your response now, I'm picking this up because it does concern me.
Yeah.
That you seem to have been too involved in prosecution and also jumping over almost other, because you had a DPP, you had a DPP. The DPP says, no, come, NDPP, and deal with the court matter.
Yes. No. I think you have it wrong, Minister. Yeah, it's the NDPP.
Help me understand it
in
properly.
In this, the NDPP doesn't deal with prosecution decisions. There's no need, but the NDPP is present. to
Yeah, I want to
basically-
understand your role here. What were you doing?
No, it's
Because
just to
you
be
didn't
around.
explain.
No, it was for the NDPP to be around and deal with third parties, those who are protesting, and to assist the prosecutor by just being present and calming everybody down. The issue is,
Was
it's almost like the
support.
Northern Cape
It
one.
was more support.
Yeah, it's more support. You do nothing. You just
Yeah.
go and support.
No,
everything.
that's why I'm asking, because you didn't specify.
Oh, yes.
And then it almost looks like you are the one who was going to court
No, we
to
support.
deal with the matter.
No, the only matter where I went to court myself was in the Northern Cape.
What was happening there?
Yes, I deal with it in paragraph. Same document, I deal with it in. Is it this paragraph? Okay, it's not in this document, but it's one of
I
the
didn't
cases I
pick that
explained.
up.
The document on dated 20.
Did you pick that up? On which document? paragraph 4. Yeah, it just says it is common cause that I'm the only NDPP ever to have roped and moved a case in a court.
Oh, I don't deal with it in
Oh,
detail.
I didn't even know. I
I
didn't.
can't remember where I may have put it then. But no, I did submit it. I did submit it. No, I did submit it.
No, it's this one.
I did submit it. I can't find it now. But effectively, no, I did.
Paragraph 3. In the start of the prosecution of the chairperson of the NC, Mr. John Block. In this case, I personally roped and moved the bail application
it's in paragraph
on
3.
behalf of MPA
Yes. There
and
was-
attended the bail appeal in the High Court.
Yes. It's the only time where I specifically roped at the request of the Northern Cape team. No, they were all there, but they were fearful. The situation was problematic from a security standpoint. And over time, the DPP requested that I come and assist the team. Because Northern Cape was small and everybody knew everybody, the prosecutors didn't want to go because they feared being identified. So I brought a team from KZN to go with me, to go and move the application. And I then moved that application.
I think it's late at night as well. You'd understand my discomfort where I'm sitting.
Yeah, I'm sure to be explained to you.
Because when we say, let me come to this point. I have an issue if we would say that NPA would have a DPP, would have prosecutors that operates with fear. And it will have to take an NDPP to have to go into a court, because when there's a review to be brought in, you've nullified yourself. I don't know the legal language they will have. I don't pretend to be a lawyer. So I specialize in my own areas, and that's why I would go into the areas. But in understanding the policies and the role of the NDPP,
Yes.
you could have easily compromised that case, because if the review is to be brought, where do they go?
The review of what?
Of that case. Let's say there's a
It's in court.
representation.
It's reviewed in court.
There's a representation to the DPP. DPP decides yes, and you think then it's brought to you to be reviewed. Because the fact that the person is charged at bail doesn't mean that the case is done. It can still be, there can be a request for representation.
Yes, a bail is not a trial, Minister. They
Yes.
can still be, no, you're not functus officio on that basis. Bail proceedings are completely separate from criminal proceedings, like trial proceedings. It shouldn't apply there. They could still review. Or make representation, sorry, if that's what you mean. Because they'll be making review on the merits. Bail is a separate sui generis.
So you only got involved at a bail.
Only the bail.
And then what happened? Their fear of crime, what happened? It diminished. Then they carried the case.
Yes, they did after a while. Well, there was a broader intervention.
Remember, I'm coming with your logic.
Yes.
That I went there because they said it's a small province. We will know each other. Therefore, there was no one I could send except myself as a leader. Go take it, and I move the bail. But then I'm asking about this because I'm assuming from where I'm sitting that the fact that these people were scared, it means you would have had to take the responsibility. Now you are saying, no, I didn't take the responsibility of the case. I moved out.
Yes.
Now I'm asking, at the time you moved out, the same team took the case further.
Yes, there were other arrangements that were made around security to diminish that, because the matter was reported to the police, and the police had to intervene and create an environment where, going forward, that to be diminished.
Okay, so we
Yes.
couldn't do that at the beginning.
No, it initially couldn't be done.
Why not?
Well, that's what the DPP indicated to me, that they've tried everything. They request that just as a start of this thing, can they be assisted on that basis?
But why didn't you do that instead of you going to the case? Having experience in the justice cluster, the network that you'd have had, being former DG, obviously you'd understand, you'd know who to reach out to be able to do that. Why was that not done instead of you going to court?
No, it was still done, even for everyone, including myself. That was done, Minister. It was decided as the prosecution that let's do it this way in order to attend to the threats and in order to attend to just the fact that we need to get started one way or the other. So to get started, right now, those prosecutors and the DPP couldn't do it. For example, I'd ask the DPP, but what would be a problem if you did it? I could come and support. They wouldn't have it. So after a lot of discussions, the conclusion was, just help us get over this line, and then going forward, we'll see how it gets managed. And that's how the intervention continued over a period of time.
Mr. Mtlou, and then
Thanks, Minister. Maybe this miscomprehension of the facts as you presented them. My impression was that you actually attended to that matter. You appeared.
Yes.
You appeared. Now, the issue of having now compromised yourself in as far as in the event that there would be further review processes, representations that are to be submitted to your office, you would have rendered yourself unavailable to attend to that, in that you would be functus officio in that space.
No.
Because you would have had intimate knowledge of the matter.
No.
You would have dealt with the matter at bail stage.
No. It's a bail application.
Yes.
Mr. Mtlou.
Yes.
As you know, a bail application is still a matter pending for investigation. And all that is being decided in a bail application are bail-related issues, only that and nothing else. It doesn't deal with the view on the merits.
That's actually not really cast in stone. You could have a situation, unless you're saying in that specific matter, merits were not dealt with. But it's not cast in stone that in bail proceedings, you would not necessarily get into the merits.
No, in this case, it was purely about whether there is bail, and if there is bail, to what amount.
Okay.
Yes, thank you. I just want to check if this process of your intervention in the Northern Cape was formal in a sense of correspondences, documentation, and so forth, that is there, or it was communications, one phone call here and there before you entered the space. But also, if you can, for the purpose of this context, indicate whose case was this and why had it become such a big deal?
Yes, there were formal meetings that took place. The reason why there were also formal meetings is because the subjects of the investigation in KZN were also in the Northern Cape. That's why it was easy. It was basically the same case, but in two provinces in terms of the individuals involved. So there were multiple teams meeting, not teams as in like physical meetings that took place to discuss what should be done. I'd gone to Northern Cape earlier before this particular date, and the team that side had come to Pretoria a couple of times, and that also met with the KZN team. So there is a formality to it. The DPP in Limpopo will confirm it because she's since been transferred there from what I understand. What was the other part, Prof?
Just for the sake of this, who was involved in this case? Why would it become such a big deal so that people following this case don't think that a small village, ward councillor was involved, therefore people start fearing everything? Why was it a big deal?
No, I think the difficulty is that one of the individuals being charged was the chairperson of the ANC in the Northern Cape. That was the difficulty, and there'd been mobilization to support him as there was. So that was the concern.
Okay. Thank you very much, Advocate Similane. I'm happy to announce that we have come to the end of this interaction. And thank you very much for making time to interact with us.
Thank you very much. Appreciate
and
it.
making yourself available.
Thank you very much. Thank you.
And have a lovely evening.
Thank you, you too. You too. Thank you.